So we are notifying clients that as at 16 May, BIPA has now officially started with the deregistration in response to a beneficial ownership declaration non-compliance. What this means is that our clients or stakeholders have been notified from 7 August 2023 of the introduction of the beneficial ownership declaration by all juristic entities, that is your close corporation members or directors and or shareholders or ultimate decision makers that have 25% or more ownership over a juristic entity. Now, we've had a number of clients that had submitted their documentation, which we are ever grateful for, because it has improved our capacity to illustrate that Namibia responds to recommendations. This boils back to Namibia's membership as a UN member state, because we report to the Financial Action Task Force, and Namibia falls under the Eastern and Southern African Anti-Money Laundering Group that meets every few months for mutual evaluation across all the countries in the Eastern and Southern African subcontinent section. To indicate how far we've progressed in terms of complying, how far we've complied with the recommendations provided. Namibia has received a number of them, the key one being the amendment of our legislation. You will see that the Trust Administrations Act was amended, the Financial Intelligence Act was amended, and so was the Close Corporation and the Companies Act to accommodate not only the introduction of the beneficial ownership information, but also the submission of this information, and then also the enforcement should then be non-compliance. So since 2023, BIPA has gone into the regions. We've engaged clients at various touch points all over the country. This also includes engaging clients at trade fairs, communicating via email and SMS, and then also communicating via our website and our social media and print media, of course, and radio and television. So BIPA has been reaching out to clients extensively across the board to try and encourage and improve our compliance rates. At present, the number is not as high as we would like it to be, but because we had already imposed penalties in 2024 and then suspended them because of non-compliance or late submissions, the last stop is to introduce the deregistration due to BO non-compliance. And once again, it is for the country to then go back to the mutual evaluation and indicate that Namibia not only passes laws, but we enforce the law as far as possible. This is ultimately to ensure that Namibia doesn't become a tax haven for tax evasion, for the proliferation of terrorist funding. So that means that Namibia, money that comes into the country doesn't fund terrorism activities, but also that we are tightening up any loopholes in our legislation with regard to anti-money laundering as well. So the encouragement to all our stakeholders is really for all registered entities to submit and declare their beneficial ownership information, because it also affects the potential interests of investors in future, because our non-compliance will move us from grey listing to blacklisting.
Now, you did mention there that the numbers are not as high as you would like them to be. What are some of the challenges or issues that BIPA has identified that are a contributing factor to these low numbers?
One of the key ones is when members of a CC, whether it's a sole member or people who are members collectively, all pass away and do not communicate to their next of kin that they are indeed members of a CC or a juristic entity, and so this entity is now just lying dormant and no one knows about it, and no one has declared that the people are deceased. Another side of the coin is also that this is simply an ignorance, and it's difficult to decipher what is leading to it. But it could be that at the point of registration or incorporation in the beginning, that our stakeholders were never notified that they have a juristic responsibility towards BIPA, same as one would have for NAMRA and your social security, and if you are in tourism, the tourism board, or if you are in finances with NAMFISA. So it could be. It's also that there's a certain level of ignorance and somewhat an inertia for lack of a better word, towards complying with BIPA.
You did also mention the cleaning up the business registry. This can be either by deregistration and so forth. Talk to us about the long-term goals of this compliance and deregistration efforts in terms of then cleaning up the business registry and improving the ease of doing business in Namibia. Yeah.
Ultimately, when the aim really is to encourage everyone to submit their beneficial ownership information, because we want to show and prove that Namibians are responsive, Namibians are interested in the protection of the country with regard to anti-money laundering protection policies and the proliferation of terrorist activities. But to do so, unfortunately, should a juristic entity not be complying, they will unfortunately need to be deregistered. So the long-term goal here is to prove that we are improving our compliance rate. Yeah. Because ultimately, once again, the country will be penalized as a whole because of the non-compliance of the few, or rather the many in this instance. So it's really critical between now and when a juristic entity would be declared as deregistered, for entities to come forward, even those that don't know, even those who had submitted their applications or applied with the Directorate of Business Registration under the Ministry of Trade in the early 2000s and earlier, because we do have entities from the early 1900s, entities from the 1930s, 40s, 50s, 60s, 70s, all up to 2025. And what we've noticed is between 2019 and up to 2025, these are most of the, if not all of the compliant entities. It's more the earlier ones that haven't complied as much as yet. And unfortunately, they are the majority. So we need as many of our clients to come forward and submit their beneficial ownership information as far as possible. They can get these documents either from our website or from the nearest Ministry of Trade office, which is now the MIME office across the country. And these documents they can submit in duplicate, and their copy would then be sent back with the stamp and the reference number. But what is critical is that these all of these entities are listed as at least compliant. At the very least, that their documentation are is received by the Registrar of Companies and Closed Corporations.
Romancia, as we conclude our conversation this afternoon, what would you like to say to business owners listening right now, whether they're in Ongwediva or beyond, about their responsibilities and opportunities under BIPA's regulations?
I think what's very important to understand is that once a company or once a CC is deregistered, whether it was operating or was a successful selected bidder for a bid, or in other words, a tender, whether you are in use, whether you're busy operating on the tender or were considered for the tender, or even in agreement with someone or another entity for a business opportunity, you forfeit that opportunity the minute you are deregistered, because that means you are no longer a legal trading entity. And restoration can be tedious, especially if findings indicate that the compliance was indeed not there, especially from a BO perspective. Once the registrar deregisters you, the restoration of the entity can be quite tedious, because we are busy with the deregistrations right now. You will have to prove that the deregistration was erroneous and that you did indeed submit the benefit or declare your beneficial ownership information. So what's critical is for every juristic entity owner to try as far as possible to submit their information as far as possible. We are aware of members that are deceased and are handling or treating those cases on a case-by-case basis, but it's not for everyone to now make claims, because we will have to verify the information against what we have on our system and in our archives. Be that as it may, I would like to urge all business owners to please submit and declare their beneficial ownership information as far as possible, because this, especially once Namibia, we don't want Namibia to move from grey listing to a blacklisting, because that makes trading even harder for Namibians outside of the country. Moving funds across the borders becomes difficult, it's already difficult right now. I'm sure many of us have witnessed how an EFT that you could move from your own personal account to another personal account in another jurisdiction now requires the intervention of Forex, which is even more tedious and costly. And we want to get out of that space as quickly as possible. So to do that, we really need to get as many of as many business owners to submit and declare their beneficial ownership information, be it a fishing rights PTY, especially those ones that were dormant. The fact that it's dormant does not mean it is actually deregistered on our side. It needs to you need to apply for the deregistration voluntarily for us to deregister it. Until then, whether it's trading or not, the entity is still listed on our register. And so we need all of these people to come to the fore and declare their information as quickly as possible.